Well, good morning, everyone. My name is Ann Simmons Nicholson. Simmons was my practice husband's name. Nicholson is my perfect husband's name. I am the CEO of the Simmons Group, and we're here today to give you some information about the Families First Coronavirus Act. We know that this is confusing information for most people, and we also know that it has been changing so rapidly that we are going to offer to anyone on this call or anyone that you know needs help. My business partner and I will be offering free pro bono, no charge, just to be clear, assistance to each of you individually. You'll have our emails a couple of times throughout this presentation. We just think it's very helpful for people to, we just think it's going to be very helpful for people to have access to a resource that actually does this for a living. If you have not already muted your computer, please do so that we can make sure that the information that comes through is clear for everyone. So please mute your computer if you have not. And I am going to keep going here. So that is me a couple of weeks ago. I am way late for a haircut, so I look very different right now in your video screen if you have that up. And I have a lot more gray hair versus 2 weeks ago. Again, I am the president and CEO of the Simmons Group. We are based in Las Vegas, Nevada. We work all over the world in human resources, organizational development, executive coaching, and training. We are going to give you as much information as we can. Oh, I just got a note that my slides are not up. So I am going to ask for that technical assistance from Tara.
Hi, Ann. You should be able to share screen.
I thought I
did. The tab is right at the bottom.
Yeah, I thought I did. Let me double click that. Oh, you know what? I made that too small. 1 second. Share. Did that work?
Yep, they're coming through great. Awesome. There you go.
Oh, me and technology. Holy cow. So this is the picture that doesn't look like me anymore. A little late on my haircut, and now everything's closed. So let's jump right in to the agenda. I'm going to ask that we hold questions. Certainly you can, through the chat, send questions. I believe I'll be able to answer most of your questions as we go through the slides. And again, if you have not muted your computer, please do so. So a quick agenda. First of all, we've got some good news, and I think everybody could use a little bit of good news, so we'll talk about that first. Then we're going to talk specifically about the Families First Coronavirus Response Act, and I'm going to do my best to not use acronyms. It's called the FFCRA. However, I am going to tongue twist myself and use the full name every time. There are two things that are, well, three things really. There's what leave is available for your employees. What is the coverage for your employees and your obligations under the Families First Coronavirus Response Act? What are the tax credits that you can begin to take, as we understand it, effective April 1st in that tax quarter? And please know that things are changing rapidly. So stay in touch with the Simmons Group. We will be providing our emails a couple of times throughout. And we will also be providing all of these slides. Tara will be sending these slides to everyone who is registered for this conference. So you're welcome to take snapshots and anything else that you want. However, these slides will be coming to you at the end of the, as soon as Tara can get them out. In addition, yep.
This is Pamela. I just want to let everybody know that we're recording this. So Tara will also send a link out of the recording.
That was the next thing I was going to say. Thank you, Pamela. We've asked, because everyone is doing this right now, it's taking a little bit longer to get the recordings prepared. So we anticipate it being out no later than Monday, hopefully sooner. So thank you for that reminder. I'm going to go through some other important stuff that is not exactly part of the Families First Coronavirus Response Act. However, there are questions that most small employers are asking, things like layoff versus furlough versus compensation cuts. Oh, look, there it is. I'm so good with my agenda. And then if we have time, we'll go through a couple of examples. However, I don't think that's as important as us being able to answer your individual questions. All of you are muted. If you are not muted, please mute your computer and feel free to send questions into Tara. She will be tracking them, keeping them for us so that during the question and answer session, if I haven't answered it, we'll make sure to answer all that we can. We're scheduled for an hour. It may go a little bit longer. Those of you that need to drop off, we certainly understand. And again, you will have access to us, the Simmons Group. I have almost, oh, this is painful, almost 37 years of experience in HR and OD. My business partner, Amy, is getting close to 20. We both started in kindergarten, so that's why we have that many years. So first, let's start with something good. The Senate and House voted, or sorry, are to vote today on the stimulus, what we're calling the rescue package. This is simply to get people to be able to pay their bills, to be able to put food on the table, to be able to have cash in their pocket. 4 big components of this, as we understand it, is an extension of unemployment benefits by 4 months, and unusual or different than what standard unemployment covers, it includes contractors and gig workers. The part of the package, the stimulus, what we're calling rescue package, is that it will provide $1,200 direct checks to most Americans. There are certain levels of income, et cetera, but know that many of your employees, perhaps many of you, will receive that check. It accounts for grants, not loans, to small businesses, which is a breath of fresh air for those of us that don't want to take on either additional or any debt. And then it also allows for loans for larger businesses. So assuming that it passes today and President Trump signs it into law, we will be able to have quite a bit of relief, if you will, at least a little bit of relief from the stress. It's anticipated that a second package will be needed, and that's the one that we're allowed to call a full stimulus package, because it will be past everyone's what they're calling survival mode, which is where most people are right now, or many of our colleagues are. So that's the good news. We do think that I would be, well, we'll see what happens once they vote. The Families First Coronavirus Response Act overview. I'm going to start with an overview and then I'm going to go into each of the individual components. It was signed into law on March 18th by President Trump. And originally we had 15 days to implement, which would have made it April 2nd. We were told yesterday that it will go into effect on 4/1. The Department of Labor sent out that notice just yesterday. So remember, things are changing so rapidly. Please email us. We are happy to provide you with facts, not fear. And we will also we have several legal firms as well as publications and associations that we are collecting data from daily. I would say over a dozen different organizations. We are doing our best to take that funnel of information and narrow it down to the information that's going to be most helpful to you. So the act allows for paid and unpaid leave for coronavirus related reasons. There's emergency paid sick leave. If you hear someone talking about EPSL or EPSL, I've heard it called, seriously, the emergency paid sick leave. That is one of the things that the act requires. It also requires emergency family and medical leave, which is EFMLA, which expands our FMLA. It expands the reasons why people can take FMLA. I'm doing my best to slow down. I talk way too fast. So I'm going to take a breath and slow down. It also allows for reimbursement to employers as tax credits. It's 100% reimbursement through tax credits. And then it also has emergency unemployment insurance stabilization and access. This is the unemployment insurance funding that allows for immediate access to unemployment as for states that don't already have that, as well as potentially even extended unemployment benefits. So the emergency paid sick leave, how it's going to impact you the most is that employers with 1 through 499 employees, and that is employees that you are counted if the employees are counted if they're part of the United States, District of Columbia, or any territory or possession of the United States. So the Marianas Islands, there are different territories that are included. My guess is most of you fall into this category, otherwise you wouldn't be on this call. Any employee who works for you is eligible. So there's no waiting period. There's no minimum days or hours required. And this is in addition to any leave that you already provide. So that's a question that often comes up. If I already offer leave, do I substitute this emergency paid sick leave with the leave that's already offered? The answer is no. It is in addition to any leave that you already offer. If the employee is sick, they're entitled to full-time employees, 80 hours of paid sick leave, obviously 2 weeks full-time, 40 hours each week. And if they're part-time employees, it's based on the average number of hours that that employee worked in the last 6 months prior to taking leave. If the employee is less than 6 months, then you can use an average number of hours per week that the employee would normally be scheduled. This is the, again, 100% is reimbursable, and I'll get to that through the tax credit. So here's an important slide that I've done a couple of things to, and I'll explain why. We must pay or provide this paid time to the extent the employee is unable to work or telework due to leave. And there are 6 reasons. Now we'll talk about the telework more specifically, but I want you to understand that teleworking is still working, assuming that you have the ability to do that, your company has the ability to do that. So the 6 reasons are: the employee is subject to a federal, state, or local quarantine or isolation that is related to COVID-19. The employee has been advised by a healthcare provider to self-quarantine due to concerns. They've had one-on-one contact with someone who has been diagnosed or has shown symptoms, or the employee is experiencing symptoms of COVID-19 and seeking a medical diagnosis. So you'll see that this does not necessarily mean they have been diagnosed. It is with the, what is everybody using? With the utmost caution, these are the reasons that you would provide paid sick leave to your employees. There are 3 other reasons. I've changed the color into purple because it's my favorite color and I'll remember it. The 4th reason that an employee, we must provide this, is the employee is caring for an individual who is subject to an order or self-quarantine as described above. So those first 3 reasons. You'll notice this does not say a family member. This is anyone that they are providing care for. So that's a big difference between what would typically allow for some sort of benefit like this. The employee is caring for a son or daughter if school or childcare is closed or unavailable. And the 6th reason is the employee is experiencing any other substantially similar condition specified by HHS, or the Health and Human Services. Sorry, there's an acronym, Health and Human Services. This is what's called the catch-all. And this is where we, as HR practitioners, we get a little bit worried that people will say that people may attempt to use this for something other than COVID-19. So as we go through this, there's a big distinction between the first 3 reasons, qualifying reasons, and the last 3. And that primarily is what they will be paid. So let's talk about the first 3 reasons. Reasons 1, 2, and 3. Again, I'm going to put them, they're compensated at the higher of their regular rate, the federal minimum wage, or the local minimum wage. Whichever of those 3 things is the higher number is what they are compensated at. The cap is at $511 per day, or $51.10. Obviously, that's simple math. Even I can do that math. Per person for the qualifying reason. So that's 2 weeks or 5 business days at $511 per day maximum. So if their rate is the highest rate, but it's more than $511 per day, you can cap it at $511 per day. These are the 3 reasons. Again, they've been quarantined. They have been advised by a healthcare professional to self-quarantine. It could be an underlying health condition. It could be they've had contact, or they're experiencing symptoms. The second 3 reasons is paid at 2/3 of the employee's regular rate. So these are those 3 reasons. Again, the employee is caring for someone else. There is a closure of a school or childcare, and they need to take care of those kids. And the employee is experiencing any other substantially similar. This cap is at $200 per day. And can I remind everyone to please put your computers on mute? Thank you so much.
Hey, Anne,
Yes.
Tara, can you just mute everyone across the board? Tara?
Everyone is typically muted across the board, even when they come in, and I remute them, but sometimes they unmute themselves.
Oh,
So
Okay.
if you would please just refrain from unmuting, that would be greatly appreciated.
and we will give you a chance to unmute when we get to, I believe, when we get to the question and answers, depending on how much time we have, and how I can be here as long as you need. So the last 3 reasons 4, 5, and 6, where we must provide this emergency paid sick leave, it's capped at $200 per day for these first 2 weeks, or $2,000 in aggregate per person. Again, simple math. If they're part-time people, that usually will be less, depending on how they're paid or what they're paid. So let's talk a little bit more about what we know from an exemption standpoint. Healthcare employees are exempt from this emergency paid sick leave. Sounds sort of crazy to us. However, that is the case. My belief is they have other things in structure, other leaves in their pay structure or in their agreements. However, at this time, healthcare workers are exempt. The Secretary of Labor has the authority for good cause to issue regulations, again, to exclude healthcare workers. And it has the ability to exempt small businesses with fewer than 50 employees from the leave to care for a son or daughter if school or childcare is closed or unavailable. I highlighted this because, ladies and gentlemen, we would suggest, with an abundance of caution, and so that you are not fined in any way, that you pay this. It's 100% reimbursed through tax credits. If your tax credits do not, if what you pay out is larger than your tax credits, we are told that you'll be reimbursed very quickly for that difference. And I would tell you that it is very important that you follow these guidelines. I believe it's going to be very rare that someone is going to be exempt from offering this emergency paid sick leave. And there are a couple of things to keep in mind. The other reason that the Secretary of Labor can issue a regulation is as necessary. This is if they missed something. It's called the catch-all. So there are some additional general rules. Sick leave does not carry over. People cannot carry this over after December 31st. Employers may not require employees as a condition of paid leave to find a replacement to cover their scheduled hours, which seems like common sense, but I'm told that's the least common of all the senses. So they put it in the bill, or in the law, excuse me. Employees may first use this paid sick time under this law before other paid leave, and the employer may not require employees to use other paid leave provided by the employer before using this paid sick leave. So again, this is in addition to any paid leave that you already offer to your employees. There are a few notice requirements. We are required to post a notice regarding these requirements. However, the Secretary of Labor was supposed to give us a model public notice. We have not yet seen that model public notice. Here's one great website for everyone to have in their back pocket. It's dol.gov, Department of Labor, dol.gov. And your state, you can actually link directly to your state Department of Labor through the federal dol.gov. Ideally, this notice will be up. However, you've now been made aware of it. Just because the notice isn't up doesn't mean you don't have to abide by it. So you do have to abide by this law. Employees, after the first workday or portion of the workday, the employee receives paid sick leave. You may require them to stay in touch with you. You may require them to provide reasonable notice. For the most part, that is going to be that they call you and say, yes, I still have a fever, or yes, I'm still sick, or yes, I'm still under a doctor's care. At some point, if the employee is admitted to the hospital, they will obviously, and they're unable to notify you. That doesn't mean that they have failed. It means that they are unable to. So it's reasonable notice, assuming they're able to. And April 1st is the effective date. Until yesterday, that was April 2nd, and it expires on 12/31/2020. We've been told that the COVID-19 may come in waves, which is not the best news. So they are leaving this available and open through the end of this year. And it is possible if we get a second wave in the late fall of this year that they will extend it. However, at this time, it expires on 12/31. And the tax credits, I'm sure most of you are wondering about this. So all of us that are subjected to these requirements are entitled to 100% refundable tax credit in the amount that you are paying out for qualified sick leave. And it's per quarter. They're capped at the same numbers that I gave you before. So you can't claim more pay than what you actually pay out. And again, for reasons 1, 2, and 3, that's $511 per day. Or the state minimum wage or federal minimum wage, whichever is higher, and then $200 per day per person for reasons 4, 5, and 6. The tax credits are applied against your Social Security and Medicare taxes, but employers are reimbursed if their costs for qualified leaves exceed the taxes they owe. We have been told that the ability to be reimbursed will be simple criteria and simple language. We have not seen that language. It has not been sent, to our knowledge, it has not been sent out yet. And you will be able to take these credits in the quarter starting April 1st. So we are saying, the second thing is it also applies to your qualified healthcare plan. So the cost to maintain your group health plan also can be included. And we are telling you that this is still a little bit confusing, and your tax professional will probably have the best information. We anticipate sending out more information when we have it available. This is something that you will, again, because it's reimbursed 100%, we want to make sure that you are checking before you take that credit. It's what you pay on behalf of the employee to Social Security, the federal taxes of Social Security and Medicare. What we've been told is that you'll be able to reimburse yourself immediately in that quarter, which means you would not send the check to the federal government. You would send it to, you would keep it. You still have to account for it. And so your payroll provider may also be a source for you for additional information. Okay, so I'm going to tell you that this is the next step. I know there are a number of questions. I believe I can answer some of those questions in this section. And I will, once I get through this section, I'm going to talk a little bit about furloughs, layoffs, and cuts to compensation. And then I'm going to probably move to questions just based on time. So the Emergency Family and Medical Leave Act, again, it's the same criteria if you're in the US, the territory of the US, Washington, D.C., same criteria as the emergency paid sick leave. Separate entities will be one employer if they meet either the joint employer or integrated employers test. Please don't start sending questions about this. We are happy to talk to you. Please don't or put them in the chat. We are happy to talk to anyone who is wondering if they fall into this category. If I have a number of different locations, restaurants, a number of different locations where I've got people working that I'm wondering if I fall into this category, please email myself or my business partner. You'll see our emails shortly, and we will answer that question to you one-on-one. Significantly expands FMLA on a temporary basis for only one reason. I'm putting my finger up intentionally. There's only one reason that people will qualify for EFMLA, and that is that the qualification is they've been with you for 30 days prior to the leave, and they have a qualifying reason. The requirement for 12 months and 1,250 hours has been suspended. So if they've been working for you for 30 days, they will qualify for this one reason. And it provides 12 weeks of job protected leave. It's paid after the first 10 days, and I'll explain what that looks like in just a second. 12 weeks of protected job leave only if they are unable to work or telework due to the need to provide childcare for a minor child. It means under the age of 18, their school or place of employment or place of care has been closed due to the emergency. And I will tell you, this is not typically covered under FMLA. This is the only reason that EFMLA would apply. The work or telework, you may decide that they're not being productive enough if they're teleworking and put them on this EFMLA or recommend that they go on EFMLA. I used an acronym, the emergency FMLA, or it may not be feasible for them to be able to telecommute. If they can telecommute, then they are not eligible for this leave. Likely, it has not been defined specifically, but we would tell you to follow the guidelines of son or daughter that is in the standard FMLA, which is step variety. If they have stepchildren that fall in this classification, that they are unable to go to school or childcare, we would tell you that it's very likely they would qualify. We do not think that in-laws, because under FMLA for caring for an in-law, if someone is under 18 and they are married, we think they should probably be on their own with this. However, right now, we would say stepchildren and your natural children. Or adopted children, any child that would be a foster child, any of those qualifications that are in FMLA would qualify for this. It has been identified as a public health emergency that happened back in March, and it has been declared federally, and most states, I think at this time, have declared it. So here's how it works. The first 10 days of EFMLA may be unpaid. However, if you remember reasons 4, 5, and 6, number 5 covers this item, this first 10 days. So we believe that most will use the 10 days of paid leave from the emergency sick pay leave under this act. They will get paid at 2/3 of their salary. An employee may elect to substitute accrued PTO, vacation, or sick leave to cover any portion of these first 10 days. Here's what that may look like. I fall into this category. I have children that are not, I'm looking to see if these text messages are someone telling me to slow down. I have a child that falls into this category. The provider has closed because of COVID-19. I apply for the emergency sick pay leave under reason number 5, which pays me at 2/3. I can use any accrued PTO or vacation time to make up the difference on those first 10 days. So I'm made whole for those first 10 days. You would pay the up to $200. And then if I make more than that, I can use some of my PTO or earned leave from my company to make up the difference. An employer cannot require an employee to use that. It's not, the law says that you can't do that. After the first 10 days, the employees are compensated at 2/3 of their regular rate, and part-time employees or irregularly scheduled employees are entitled to be paid based on the number of hours they've worked in the prior 6 months, similar to the emergency paid sick leave or the average number of hours that the employee would normally be scheduled to work. This is the exact same language as the emergency paid sick leave. And the pay is capped at $200 per day, $10,000 in aggregate per employee. Whew, a lot of information, and some of your heads may be swimming. I promise you, we are happy to answer your individual questions. Some exemptions may apply. Again, the healthcare workers are exempted, and the Secretary of Labor has the authority for good cause to issue regulations to exclude healthcare workers. And again, I highlighted this to exempt small businesses with fewer than 50 employees. I need to look at my notes on this because it's very specific. So if you believe that providing this leave would jeopardize the viability of your company as an ongoing concern, you can apply to be granted this exemption. Again, we've been told that there will be simple and clear criteria. I have not seen that criteria, so I can't confirm that. And what I would tell you is that you are wise to provide this leave if people fall into the classification that their minor child has, their school or place of care has been closed and they are unable to telecommute. At some point, you may be exempted from this. Because it's being 100% reimbursed, it's our position, our belief that it is going to be rare to get an exemption, and there may be one out there there may be reasons out there that you would be exempted. So what the Emergency Family Medical Leave Act allows is that if you have 25 or more employees, you will have traditional restoration obligations. If you don't know what those are, we'll be happy to explain those to you. If fewer than 25 employees, the traditional job reinstatement provisions of FMLA do not apply if there are a couple of conditions met. Also note that you still have to provide the emergency family medical leave. You just may not have the same reinstatement criteria. So if the employee takes EFMLA, first of all, they have to take it in order to, of course, be reinstated. And the position the employee held when the leave started does not exist anymore due to the conditions or other changes in the operating conditions of the employer. So let me just put this in really simple language. If somebody takes EFMLA, they qualify for it and they take it. If you end up having to lay off everyone in that category of position, or you have to shut down a department, or you have to otherwise make decisions for your business, they would also be impacted by that layoff. You still have to provide the EFMLA until such a time when the schools reopen or the place of care is available again. So I know that's confusing, and if you've got specific questions, I've said this 100 times, I'll say it again, we will be happy to talk to you about your individual situations. Job restoration and reinstatement is also, it's required that you make reasonable efforts to restore the employee to an equivalent position with equivalent pay, benefits, and other terms. And if reasonable efforts to restore them fail, meaning you can't restore them to that position, then there's a 1 year, and this is a change from FMLA. There's a 1 year period that this law is asking you to reach back out after they have qualified for the need. So the date on which the qualifying need or is related to the public health emergency concludes. So let's say that they release the public health emergency on May 31st, and that employee can't come back to work. That's when the clock starts ticking on the 1 year. It can't come back to work because you don't have the job, or they can't come back to work for whatever the reason. Or the date that is 12 weeks after the date on which the employee starts the leave. So if the emergency lasts past the 12 weeks when they started the leave, that's when the clock starts ticking. Let's hope it doesn't last an additional 12 weeks after April 1st. However, it may. So that is a lot of information. I understand that it can be very confusing. We promise you we will help you get through your individual situations. How this interplays with other leave. Full-time employees may take emergency paid leave for the first 80 hours. Again, that's paid at 2/3 of their pay. And they may also elect to use other accrued leave vacation PTO during that first 10 days to make up the difference in what the 2/3 pay pays them and what they actually make. Their eligibility for EFMLA and FMLA is 12 weeks total. So this means use of EFMLA may affect their eligibility for other FMLA in a 12-month rolling calendar, and it may not. We've heard both, that this is intended to be supplemental to FMLA, and it may or may not be supplemental. That has yet to be decided. We actually think that the Senate has stopped looking at this bill because it's the Senate and the House, because it's been signed into law. So we'll get to handle that as it comes up. There's no specific new notice required. However, under FMLA, you should be displaying, if you have over 50 employees, you should be displaying the FMLA poster. Where the necessity for leave is foreseeable, we do ask that employees provide us notice as practical. So I'll give you an example. My neighbor's husband was taking care of her or him, and that caregiver comes down with symptoms or is told to, they're unable to care for them. I find this out and I notify you today that I'm going to become the caregiver. That's as much notice as I'm able to provide you. That would qualify under the 2 weeks emergency paid leave. It would not qualify for the additional 10 weeks. So again, there's a lot of movement here and a lot of things to consider. The law goes into effect April 1st. So without sounding cold-hearted or crass, as an HR professional, I would tell you to consider what actions you need to take prior to April 1st. And that is next Wednesday. It's a week from today. So that being said, those of you that are considering things that will impact your employees, again, if it's an individual situation, Amy and I will be available. We anticipate being on the phone for the next, literally for the next week, with anyone who has a question. When you reach out to us via email, please include a good contact number, because there are often numerous questions that we have to ask in order to help advise you. And in some cases, we may say, you may need to speak to a labor attorney. Most of the time, we can answer these questions from a practical standpoint, and we're free. So tax credits, similar to, sorry if that's blocking, similar to the emergency paid sick leave, you are entitled to a tax credit equal to the amount that you're paying. They will be capped at $10,000 per calendar quarter per employee, and they are applied against your Social Security and Medicare, but employers are reimbursed. Again, if your cost for qualified leave exceeds the taxes that you owe, we are told those forms are coming to expedite the payments. We have not yet seen them. And then the credits also apply to the qualified healthcare plan. So there's the contribution that you make for your employees for the healthcare plan can be included in that credit. And again, we're going to suggest you check with your tax professional or with your payroll service. So some states have additional requirements. In the state of Nevada, you have paid leave that went into effect January 1st of this year. So there theoretically will be leave in someone's paid leave bucket, if you will, that they can apply towards those first 2 weeks. That leave, should someone be laid off and you don't pay that leave out, or be furloughed and you don't pay that leave out, they're reinstated within 90 days, then you are required to reinstate that PTO and their status. Your state, if you're not in Nevada, we are very familiar with Nevada, California, Arizona, Colorado. If you are on this call and you're outside those states, again, your state Department of Labor is going, and we're happy to review those with you also. Sometimes reading them can be quite confusing, and we are very used to reading them. So I am going to go through these slides, and this may be, you may have wished I'd done this first, because this is the layoff, furlough, and cut in compensation. So a layoff, the definition of a layoff is that there's a termination due to lack of work. It's sometimes called a reduction in force or a RIF. and it terminates the employee and their benefits from your payroll system. In the state of Nevada, you do not have to pay out accrued time, so any leave or vacation time. And should you lay someone off and reinstate them in 90 days, you would reinstate that paid time off. You may or may not be called back on a layoff. A furlough is a temporary termination due to lack of work, and it would still read on your internal paperwork, termination due or furloughed due to lack of work. It can reduce the days worked, or it can terminate, it can stop their work. It can terminate the employee's work 100%. The difference is, and this is the most significant difference, they will be kept active in your system on furlough. And if they pay their portion of benefits, they can stay on your benefits plan versus going to COBRA. That's the most significant difference. They may or may not be called back. Again, if this extends beyond the next 90 days, you may transition people from furlough to terminated, and they would be advised of their COBRA rights to be able to purchase insurance through COBRA for the next 18 months. Remember, there's a 90-day rule in Nevada. PTO balances and their status is reinstated if, hopefully, they are called back within those 90 days. Both groups are eligible for unemployment in the state of Nevada. And right now in the state of Nevada, there is no delay. Oftentimes there's a period of time before they can actually receive benefits. That has been, in the state of Nevada, that has been eliminated. They will be eligible for benefits right away. And with what, assuming that this law passes today, the benefits will be extended. Some additional important stuff, I couldn't think of what else to call it. Can I cut compensation? It's complicated, so please contact us. There are some general guidelines that I'm going to share with you, and it is complicated. We have a number of questions that we'd want to ask you before we would suggest you do that. First of all, for exempt people who are exempt from overtime, you can't cut them below the $684 per week, or you have in effect made them non-exempt. There's a 7-day notice requirement in the state of Nevada, and I believe in the state of California, but I can check that if you are considering this and you're working out of California. If they answer one email or phone call a day, remember they worked. So with an exempt, I'm going to call them exempt from overtime. If they answer one email or they answer one question, or they take one call from you or one call from a customer, they get paid for that day. Non-exempt, we would suggest you cut their hours, not their wages. And that is certainly up to you. We cannot take people below minimum wage. So that's one of the reasons that we suggest you take the approach of cutting their, sorry, I don't know what I'm doing here. I hope I'm not messing up your screen like I'm messing up mine. In the state of Nevada, it's $8.25 an hour, and you cannot take people below minimum wage. And did I mention it's complicated? Please contact us. So how do you do that? My email is here. I am ann@simmons-group.com. And Amy Hunter is my business partner. I have, again, going into my 37th year of doing this, and Amy is going into her 20th year of doing this. So we can help you. This is free. We are happy to answer your questions. Email us. Please include a phone number so that we can contact you. So I'm going to go to questions now I'm going to leave this up on the screen. I'm going to go to questions now. If you have a question that you have not already sent through the chat that has not been answered, please send Tara a message that you have a question, and she can unmute you, and we're happy to answer your questions.
Before I start going to the questions, Anne, great job. Thank you very much. Wonderful information. So Vicki, I'm going to find you here. You had quite a few questions. Hers doesn't seem to be unmuting for her, so I'm going to ask Vicki's question. One of them you answered in the beginning, but it's a two-part question. So, and she was asking if someone currently is out of work waiting a diagnosis, would this law be retroactive?
No, it is not retroactive. That's a common question. It goes into effect April 2nd. So they would not be covered under this law. You may have other leaves or other paid time off that you would allow them to take until it's exhausted. If they are still on your payroll as of April 1st, I think I said April 2nd a second ago, I'm sorry. If they're still on your payroll as of April 1st, you then may be required to pay them that 2 weeks paid leave.
Okay. And Vicky just unmuted. Her second part of the question was, she thought you would be able to claim the credit immediately upon the deposit schedule. For example, if you're a weekly depositor, would you claim that credit immediately?
We have been told that since the law doesn't go into effect until April 1st, you cannot claim the credit until your next quarter of earnings. Because the law is not retroactive, you would claim anything paid under this law in the next quarter starting April 1st. That may be the reason that the DOL changed the date to April 1 from April 2nd. And again, that may change. They may say that the government may say at some point, anything that you paid out for sick leave can be reimbursed. We're telling you, as of right now, that is not the case. It's only people that are diagnosed. They fit into one of those 6 categories after April 1st or later. Great question.
Vicky, I see that you're unmuted. Did that answer all your questions?
And Vicky, you can claim
Can you hear me?
Vicky, you can claim it weekly. You can claim it immediately as of April 1st. And yes, I can hear you now. Go ahead.
Okay, yeah, that was what I was going to try to clarify, because I have been in touch with my payroll provider, my software company, and my understanding is that since we are a next day depositor, that if we had that pay, we would be able to track that pay. As long as we track the pay, obviously for backup,
Yes,
that we could take the credit immediately on that week's payroll deposit.
you can. You absolutely can. It's one of the things
Perfect. And I'm assuming they're going to change the 941 and all that good fun stuff to track it for quarterly reporting, but we would be able to, yeah, fingers crossed, hopefully they do. We would be able to take credit immediately.
They've told us you can reimburse yourself immediately as of April 1st. So my belief is yes. And then if you pay out more in these leaves than you actually owe in taxes, we've been told also that there will be a direct method to be able to recoup those. Everybody understands cash flow. And so that is the intent, is that you can take it immediately. Great question.
Perfect. Thank you, Ann.
You're welcome.
Thank you, Vicky. So the next one that had a very good question was Karen. Karen, I'm going to unmute you. And Karen's,
I think
Karen,
that
can you
question
talk?
was answered.
Okay, it was clarified for you. So then the next one would be Annette. Annette asked, what do you mean by regular rate? Is that a daily, hourly, or salary?
It depends on how the employee is paid. So if their regular rate is salaried, you would take, so I'm going to give you this calculation. Please, if it's confusing to you, please reach out to us. We will email you this calculation. I would take a salaried person or an exempt person's salary divided by 2,080 and then multiply that number by 8. That's their daily rate if they're a salaried person. If they're an hourly person, it is their hourly rate times 8 hours a day. And for those of you that work 10-hour days, please reach out to us, because there are some additional laws in California, Nevada, and I believe Arizona that we'd want to walk you through. But the greater of the number. So if I'm going to use a food server as an example. A food server may be paid at $8.25 an hour in the state of Nevada. So $8.25 times 8 hours would be their daily rate. That is going to be less than $200 a day for the 2/3 pay. You would pay them their daily rate, not the $200 a day. If someone's salary or someone's hourly number is greater than $200 a day, you would only pay them $200 a day for reasons 4, 5, and 6. And if their rate is higher than $200 a day for reasons 1, 2, and 3, their own health condition, you would pay them a maximum of $511 a day. And we're happy to talk you through those calculations. It won't take us very long. We'll actually do the calculations with you if that was confusing to you. Hopefully that answered your question. You're welcome.
Great. The next one, it happens to be initial, so I'm not going to try the name, but the question was, if your business is still working because you are an essential business, but the rest of the state is on quarantine, do your employees not qualify based on the first provision of eligibility?
Great question. They absolutely do qualify. So if one of those 6 things happens to them, essential worker or not essential worker, they would still qualify under this act for the 2 weeks of pay if they are sick at full rate. Sorry, if they are quarantined or exhibiting symptoms at full pay, and for the last 3 reasons at 2/3 pay. And let's be a little logical, right? How many times have you heard wash your hands, stay home if you're sick? You want to reassure people that are working for you that they are going to be paid. And the FMLA, if you're over 50 employees, FMLA would apply, and the EFMLA will only be paid at that 2/3 rate if it is for child care, a minor child care.
Right. The next one is, do you have to provide proof for the 4 to 6 reasons?
That's a great question. It's not actually addressed in the law. So what I will tell you is that we can't ask, HIPAA doesn't allow us to ask for doctor's notes. The quarantine, the self-quarantine, the required by an agency quarantine, we're going to have to go on trust. If we find out, and this is something that I'm telling you as an HR professional, you want to be very careful of, let me say it differently. Most of us know way more about our employees' personal lives than we care to. So if they tell us that a family member, someone that they've come in close contact with has been diagnosed with coronavirus, tell them to stay home. It is absolutely imperative. It's the only way we're going to flatten that curve. So no, we do. I'm going to say, I'm going to qualify it that no, we will not need to have proof. Ideally, I'm going to use the state of Nevada as an example. The governor closed all of the businesses, closed all of the schools on a Sunday at 4 o'clock in the afternoon, and then closed all of the businesses on a Tuesday evening, St. Patrick's Day. Theoretically, our elected officials are thinking about reopening the schools before they reopen the businesses, and they may not be able to do that. Obviously, the economic impact of the businesses is more significant. So at this point, that was a long answer to a short question, but no, you do not have, at this point, we would not suggest that you get required proof that someone is qualified for one of those 6 reasons.
Okay, perfect. Then Kathy was asking, do the 10 days of the EPSL have to be continuous? Or can they be spread out over time, meaning that if they work 3 days on, 2 days off?
Great question. Our understanding is that if they've been quarantined and they're able to keep working, they would not qualify for the emergency sick pay. If they are continuing to work, then we would say no, they would continue to stay on payroll as normal, whether it's hourly or exempt salaried. And you may decide at some point that what they're doing working is not working for the business. So then you could put them out onto that emergency paid sick leave. So it's our understanding that if they're taking, at least for the first 3 reasons, if they're taking that they need to take it because they're sick and they're unable to telecommute. That's the best answer I can give you right now. So 10 days straight.
Okay. And then Colleen was asking, what if somebody needed it? Well, we've already addressed this question. I apologize.
That's okay.
So Brian was asking, public sector is not able to get the tax credit, correct?
That is my understanding, unless if you're in the public sector and you're paying Social Security and Medicare, which Ryan, call us separately because there are a bunch of questions we would need to ask you. You know, how are you paying into retirement, et cetera? So we're happy to answer that question individually. My understanding is that if you're paying into Social Security and Medicare, you would be eligible for those tax credits. So that's the big question, and we're happy to answer that privately with you.
This is a question about posting the notice. If your office is already closed, does emailing each of the employees qualify as posting it?
Yes, and so the posting of the notice, we have advised all of our clients, regardless of whether you posted it or not, let your employees know. And even if you don't let your employees know, you still have to provide the leaves as they're stated in the law. So you want to give people that information as a good employer. And again, ideally, you're going to want those people back when you're able to ramp back up. So yes.
Which leads us into Julie's question. Julie asked, with paying the sick leave, if the employee is sicker for a shorter period of time and can come back to work sooner.
Yes, they can. So that would be an example where you wouldn't give them the full 10 days. They're sick for a week, or the quarantine is 14 days. So for those first 2 reasons, if they're able to telecommute, they wouldn't qualify. If they're able to keep working, then you wouldn't be paying them the sick leave. If they're not able to work, theoretically, it's going to be for reason number 3, where they're exhibiting symptoms. Symptoms to the point where they are unable to work. Our information shows, the data shows that 80% of people that get COVID-19 recover, and some of their examples, or some of their symptoms are not as severe. So that in that situation, here's a typical situation. Somebody thinks they have COVID-19, they are presenting with some symptoms, they go get tested and they don't have COVID-19. They may be able to come back prior to that 10 days. You can take full credit for the days that they are out on emergency paid sick leave, as long as starting April 1, you can take 100% credit for that on your taxes. And then the other 5 days, obviously they would be back to work, assuming that there is work for them to come back to. Good question.
Okay. Part of this question was already answered, but I'm going to go ahead and ask it, and you can just refer back to it. And when an employee is telecommuting and staying at home, but they are less productive due to the fact that they're watching their children, can they supplement their work time with the benefits, or is it all or nothing?
Yes, they can. It's not required, but they can supplement. So they're working half days now. And those half days are because they're caring for children. They may use their additional time or any paid leave that they have accrued to make up the difference. As long as your policy states, yes, they can. That's a dumb thing to say. Yes, they can.
Okay, great. What rights do temporary or contract employees have?
Yeah, great question. So as of right now, temporary workers would classify under the irregular work schedule, on call, et cetera. If they are temporary workers, you would look at the hours they were scheduled to work, and yes, they would qualify. Contractors are not covered under this law. I want to caution you. If you use contractors in a way that they are primarily working for you. You may call us individually. Let's talk about that individually. But no, contractors would not be, you would not be required to pay contractors under this law.
Great answer.
Mhm.
One asked that their company is smaller than 14 employees and normally the FMLA does not apply.
Right.
Do they still have to provide the EFMLA?
Yes. The answer to that is at this time, yes. We have not seen how to request an exemption. And in one of the slides I showed earlier, it has some very specific language, and I'm going to repeat it. In order to be exempted, for me, less than 50 employees only may qualify for an exemption. I emphasize the word may qualify for an exemption. It has to be granted to you. You can't decide on your own that you're exempted from this. So the DOL has said that there will be simple and clear criteria. And the criteria, you have to show, the only reason it's going to be granted, according to what information we have now, is that you have to show that there's jeopardy of the viability of your company being an ongoing concern. So at this time, we are recommending to all clients to honor the EFMLA stipulations of this law. If there's clarity around this before April 1st, woohoo! However, I will tell you that that first 2 weeks would typically, you would want to use those first 2 weeks from the emergency paid sick leave versus EFMLA. You're going to go ahead and grant that after the first 2 weeks, an additional 10 weeks at 2/3 pay if their childcare, if they have a minor child whose school has closed or their childcare provider has closed due to COVID-19. So remember, it's only one reason that EFMLA is granted, and that is for the care of a child, a minor child, and they're unable to telecommute. For that, whoever asked that question, if you want more clarity, because I don't know what your business is, if you want more clarity, please reach out to us directly, and there's a lot of if-then questions that we would ask you at that time.
Great.
Mm-hmm.
Thank you very much, Ann. So you're probably going to tell Joanne to do the same thing, but I'm going to read you her question.
Okay.
She has seasonal employees in 2 different states.
Yeah.
And that currently I have no work due to this. So she also feels it would be very difficult to calculate their average hours for them over a 6-month period. What would she need to do?
Well, I will tell you, you said Joanne?
Her name is Joanne, yes.
So Joanne, please reach out to Amy or I. My belief is that you want to furlough or lay off those employees before April 1st. And because there's no work, that would remove you from the liability of the emergency paid sick leave and the EFMLA. And we will ask you a bunch of if-then questions during that conversation. If that happens, then when it does ramp up, will you be able to hire them as one of those rehire them is one of the questions that we'll ask. The good news is, and depending on what 2 states you're in, they will qualify for unemployment under each of those 2 situations, whether it's furlough or laid off. Please reach out to us individually. We can help provide you with the letters, the requirements, and if you have a certain number of employees, there are a couple of notifications you have to do. But it's from the information that you shared in the question, it is probably wise for you to lay them off sooner rather than later, before April 1st.
Great.
And I hate saying that. I hate saying that. And it's never easy, and it should never be easy. And we can talk you through your options.
Great. So the next question would have been from Brian. And I apologize in advance if I make a mistake in your name. So can we provide availability or make PTO supplement EFMLA paid time during the 10 weeks? The third pay difference.
If it's to pay the difference, my belief is the answer is yes. The only thing that's specifically mentioned is that you can't require people to do that. So in the law, it says that the first 10 days can be supplemented, and The law doesn't specifically address the rest of the EFMLA. It does, however, say that you may not require people to use those other hours. And it's a generous thing to do. It's a good thing to do if you can as an employer. You cannot take that as a tax credit. You can only take up to the limits that are provided by the 2/3 pay and up to $200 a day for 10 weeks.
Very good.
And if I didn't answer your question, again, reach out to me. We can talk through scenarios.
So, Erin, I'm gonna skip over your question. If you still have an additional question to that, please put it in the chat and I'll make sure to get to it. But I believe it's been answered for you. So the next question would be from Caroline. Can a furlough employee apply for the emergency paid sick leave?
Can a furloughed employee? It depends on when they're furloughed. So furloughs and layoffs. If you're thinking about that, please reach out to us. We would recommend you do that before April 1st. If they're furloughed, can they apply for the? No, they can. My understanding is no. They would apply for unemployment instead. And I will get clarification on that. If you want to reach, excuse me, reach out to me via email, I'll get clarification on that for you specifically. But my understanding is no, if they're furloughed, they are in effect, they are temporarily laid off. So the only benefit that they would stay active on would be your health insurance plan, as long as they pay their employee contribution.
The next question, I believe you already answered. So it was the dol.gov site. You had a few that were asking, was there anywhere that it was published formally on the processes for either the leave that they can use for their employees?
If I'm understanding the question, it's is there a step-by-step process for what you can do?
Right. Has it been
Okay.
published?
No, to my knowledge, no. So what you're seeing in these slides is from an accumulation between my business partner and I of the at least dozen different sources that we have. We believe this is going to be a good guideline, and we will continue to update anyone who wants to be updated based on when information changes. To my knowledge, there is not a step-by-step. My belief is that on April 1st, the first thing that's going to kick in is emergency paid sick leave. And it's pretty clear cut. If one of those 6 reasons, one of those 6 things happens, you have to provide either their daily rate up to $511 for reasons 1, 2, and 3, or 2/3 pay up to $200 a day for reasons 4, 5, and 6. And again, number 6 is the squishy one. That person I mentioned earlier that they feel sick, they go get tested, they don't have COVID-19, they would still qualify for reason 1, 2, or 3. So yeah, it's an if then, and every single employee is going to present differently.
Right, which actually leads us great. It's a great segue into this next question that I believe it's Gabrielle asked. Does number 6 in the condition list apply to for paid sick leave include any mental health conditions?
It is not addressed. It is not addressed in the act. And I'm sorry, I'm just looking. My business partner is telling me that I'm correct. Yay, I'm correct. So, so the mental health question has come up. There is not a clear decision by the DOL to be able to be able to answer that at this time. Whoever asked that question, please send it to us via email, and we will continue to ask. However, it is not clear.
Okay.
One of the reasons that has come up is I am told I'm essential personnel, but I have a panic attack every time I think about going into my job. That technically doesn't fall under the first 5 conditions. Would it be a catch-all in number 6? We have not had a significant answer. A clear answer on that.
Okay. So Marlene asked a question. She's feeling a little confused about reason number one. She states that we are in the state of California. So if an employee has no symptoms and no child care issues, etc., but because California is under general quarantine, does that mean that all of her employees qualify under provision one, even if they are able to telework?
No. If they're able to telework, the answer is no. They would not qualify under reason one. And that is a common question. Our understanding is that if they're able to telework and continue to be productive, they don't qualify for the emergency paid leave or EFMLA. So one example that comes up is I've got tweens. I've got 9, 10, 11-year-olds. I'm not going to leave them at home alone, and I'm not going to, I need to stay home because their school's closed. Usually people can put some guidelines in place for those children. They can continue to work. They would not, even though you've been told to stay home from work, you can still telework. You would not qualify for that for the first 2 weeks of sick pay, as long as they're able to work. If at some point they're unable to work, the first 2 weeks would be unpaid. However, they would use number 5 on the 6 reasons to get the 2/3 pay for the first 2 weeks. And then until the childcare or school reopens, they would get 2/3 pay for the extent that the situation continues to, so the school's still closed, because of COVID-19, and the childcare is still closed based on COVID-19.
Okay. So this question is from Colleen. She assumes that they need to track the type of pay separately.
Yes. Yes. So your payroll provider should be able to assist you. There is an FMLA tracking mechanism. There should be additional tracking mechanisms with your payroll provider, and I'm sure they're all scrambling right now to figure out how to provide that. If nothing else, paper and pencil works. Have a very clear, I'm going to call it history log, if you will. This person went out on this day with these symptoms, or they were told they were in contact with someone who has been diagnosed with COVID-19. They've been told by they have an underlying health care, or an underlying health condition that requires them to quarantine or self-isolate. Just start writing it down until your payroll providers can give you something electronic. That is going to be our best advice.
Perfect. So Francesco asked, they have a temporary employee through a staffing agency.
Mm-hmm.
Are they responsible, or is the staffing agency basically responsible?
The staffing agency is the employer of that individual. The staffing agency, let me just do a quick thought here. It would depend on how long they've been working for that employer. So again, we get into some squishy language around, have they been working for you for a full quarter solely at your location? I believe it would be the staffing agency, and it's Francisco, I believe you said. Please reach out to us and we can talk. We have a couple questions for you before we would say it's absolutely the responsibility of the staffing agency versus you.
And then Francesco's second part is that she's an essential company still operating, but business has slowed down drastically. Mm-hmm. Would the layoff of the temporary staff have any ramifications at this point with the leave coming into play April 1st?
No, lack of work can happen at any time. And so, again, let us, I don't know what your essential business is, so please reach out to one of these email addresses and one of us will get back to you. Those types of questions we will answer first, because the deadline is a week from today it's actually a week from yesterday, that for those layoffs and furloughs to happen. And so as an essential business, you may want to furlough versus laying off in case you need to call them back quickly. However, because I don't know what your essential business is, it's going to be helpful for us to talk one-on-one.
And then, great suggestion. Aaron asked, do you know how the tax credit on the amount we pay of our employees' health benefits will work?
I do not. I believe that more clarification will come out about that. Right now, it looks as though it would be the employer's premium, the employer's contribution, excuse me, the employer's contribution. However, it sort of depends. I'm going to tell you I don't know, and I'm going to tell you that there's going to need to be some clarification around that because a number of clients have asked us. And if they're still working versus are they on leave or sick pay, I believe it is if they're on sick pay or EFMLA that you would get a full credit for the employer's premium, the employer's contribution towards the premium, and the sorry, my business partner is really good about saying, yes, I agree, or no, I think you've got that wrong. So that I'm glancing at my phone to see if she's sending another thought on this. So let me say that again. If someone's out on the emergency paid sick leave or out on EFMLA and you are continuing their benefits, they are paying their contribution. My belief is that you will have 100% reimbursement of the employer's contribution towards a qualified health plan, and that would be on your tax credit.
Okay. Aaron followed while you
keep
were.
your ears open. Sorry, let me finish the thought there. I'm saying to you that is our interpretation. We may get clarification in the next week or so.
Okay, Aaron followed with the additional question while you were answering. So what about the amount we pay in the collective bargaining agreement fringes?
Great question. CBAs, call us. It's CBAs, any contracts that you have with employees, if you've got employees that are, they're employees of yours, you're paying them and they have an employment contract with you, there may be some stipulations in there about what they will get paid and how they will get paid. CBA collective bargaining agreements will also have some qualifications. We do have the answer to that. We just need to understand your CBA better.
So Aaron, I hope that helps. If not, like Ann said, please reach out to them. And I'm sure you have some additional questions. So I'm going to jump back up a little bit. I kind of skipped over this question, but just to help, Link Technologies was asking the question, what is the difference between contract, temporary, and seasonal workers?
It depends on your work. So we have a bunch of if-then questions for you. Link Technologies, please reach out to us. It's not as clear cut as being able to categorize them and then address them differently. Honestly, if you are an essential business or you are still working at full force, then we need to talk to you about how you would handle each of those groups. If you have already shut down your business, we would need to talk to you about how you handle each of those groups. So it's a little bit different, and contract employees has a variety of different interpretations. So we, again, have some questions. I know that, so we had, 107 people on the call. You probably have 130 different questions about situations. Many of those are going to be, we're going to need a little bit more ancillary information before we can give you some recommendations.
Right. Chris, I'm not very clear on your question. I'm going to read it, but we may need additional information as to what you're referring to. Chris asks, the schools may be closed through August. Can they use this during the summertime while the kids are still out?
That is a great question that we have not been asked. Our understanding is that the only thing that this can be used for is if, while normally it would be open, COVID-19, the national emergency, the national health emergency has shut it down. So I don't know what the schools are going to do about, so many schools have said the rest of the year is going to be via the internet. Some schools, some states are extending the school year by a number of weeks. So the school has to be in session in order for the EFMLA to go into effect. So my tentative answer is no, they could not take the summer off with their kids and get paid 2/3 of their pay if the school is closed for reasons other than COVID-19. If the school is a year-round school, many states have that. If the school is a year-round school, then it would qualify for the dates that the school would be in session. However, it is not because of COVID-19. So my tentative answer is no. If the school's out for the summer, they would need to take action to get the child care. Now, here's where I have to be careful, that they would need. If their typical child care has gone out of business because of COVID-19, or they are unable to open because of COVID-19, then that may be a whole nother ball game. And I will tell you that within the next 8 weeks, we're going to have a whole lot of questions. And Amy, my business partner, is agreeing with me. It has to be they closed because of COVID-19.
So here's going to be the last question, everybody, and then I'm going to also put in the chat so you can cut and paste the email addresses for Ann and Amy. So by all means, please utilize their wonderful offer and reach out to them directly for any more extensive or detailed questions you have. The last question by Ms. Wise was, what if they had child care available through other sources over the summer break? Wouldn't they still qualify for the EFMLA?
It's our understanding that no, the child care facility and or the school has to have closed because of COVID-19. So similar to the previous answer, if there's no child care available because of COVID-19, then that would, here's the other thing. If the state of emergency, the state of national emergency, or the state emergency declaration is removed, then it is very likely that they would not be eligible for EFMLA. And it may take some time to ramp back up. You will still get 100% tax credit for that EFMLA. However, if the state of emergency is lifted, my belief is they're going to be very, I'm going to say pretty strict about what you can and cannot take as a tax credit. So here's the reason that they have offered this, or that they've left. Our belief is that they've left this EFMLA and emergency sick pay open until December 31st, because if there is a second wave of the sickness, there's still no vaccine, there's still no treatment, then they may take 5 or 6 weeks now, 4 or 5 weeks now, and then they may need that additional time when school reopens in the fall.
Right.
That is our best answer to that right now.
Wonderful. And I can't say how many comments came through here because the chat rolled so fast. You had a great deal of people that said, thank you, great webinar, wonderful presentation, and thank you very much for breaking it down for them.
You are welcome.
Francesco, I know you had an additional question. I'm going to encourage you, due to the time constraints, to please email Ann and ask that question. She'll be more than happy to answer it. But we have already kind of ran over in time, and I value all of our times extremely, and I know that Ann probably has 1,000,001 emails. So if your email crashes, we're going to blame Ann for it. Because you're going to get a lot of emails.
We'll get it back up if it crashes. Folks, we know things are going to change. Please feel free to reach out to us if you've heard something, or someone tells you something different than what we've given you. Please reach out to us. We will do our best. Again, we have dozens of resources coming to us every day. We're pretty much going blind reading all this stuff, but we are very careful about giving you only factual information that we can confirm via a legal firm or an association, that the Human Resource Association or Department of Labor, places that we are confident that our information is correct. And stop taking advice from Facebook. Stop. It's not accurate.
I thought everything that was on Facebook was 100% the gospel.
Yeah, send me an email separately. We'll talk about that.
And on behalf of WeBank, yes, on behalf of WeBank West, I want to thank you very, very much for your time. I know it's extremely valuable. You brought forth a great deal of information and helped break it down for us. So I know that I greatly learned a tremendous amount by listening. So everyone, thank you all very much. And you have a wonderful day. Everybody stay safe and healthy. And again, they're just coming through flooding the chat with telling you thank you very much, Ann. So
Oh, my pleasure. My pleasure. Thank you for asking. And just so you know, Pamela and Tara, if a lot changes, we're happy to do this again.
wonderful. And I'm sure we will take you up on that.
You're welcome. Everybody stay safe, stay healthy. Thank you.
Bye.
Again, I'm just going to reiterate that the recording will be available. However, it does take a while for it to render. So as soon as it is available, I will send it out for everybody. And then we will also have it posted on our website. So thank you all very much for attending. Miss Pamela, you're on the screen, but you're muted.
I can unmute myself.
There you go.
Thanks, Anne. We appreciate you.
Of course, it's my pleasure. And this is confusing stuff. You all are experts at what you do. We actually can help you demystify some of this stuff that can be a little crazy. And again, if there's a need or a desire for another one, we're happy to do that also.
Thanks.
Have a good day, everybody. Stay safe, stay healthy.
Goodbye, everyone.
Bye.